We're gonna get this, man.
It's got an otter box.
All right.
Ready to go? Your Excellencies, we stand today before this tribunal, seeking remedies both for the restoration of Mr. Rodolfo's private property, as well as the restoration of the proper, legal order of interstate relations. Now, in light of the illegal conduct of the United States of America and its confiscation of Mr. Rodolfo's whole net worth, we beg that your Excellencies consider both restoring Mr. Rodolfo's property rights to his personal fortune, which he acquired through his own toil and industry, which was wrongly confiscated by the U.S. government, as well as condemning the United States' demonstrated foreign policy of compelling the citizen residents of foreign sovereigns as agents in its request for the release of information that is prohibited by those sovereigns, rather than engaging those states co-equally with the respect that is required by the United Nations Convention, long-standing international custom, and the general principles of international law. We will demonstrate that the actions of the United States in relation to Mr. Rodolfo's property confiscation and its interactions with the state of Narbona violate 4 international principles of law. The first is the general principle of the doctrine of acquired or vested rights. The second is the general principle of state sovereignty and non-intervention. The third is the principle of international comity. And the fourth is the duty of good faith, which is also an international principle of law. Now first, the United States violated the general principle of the doctrine of acquired or vested rights. The doctrine of acquired or vested rights comes to international law originally from domestic jurisdictions. Now for some time, it was believed by noted publicists that this particular doctrine protected individuals' rights and property from takings by foreign governments, and that such takings would be a per se violation of the doctrine. Now this doctrine has evolved over the ages and has come into accord with current circumstances of the world order in such a way that it creates more of a floor now for foreign jurisdictions and their ability to take from private citizens their property, in that it indemnifies title holders from complete and arbitrary destruction of their property interests. And we suggest that is exactly what the United States of America did to Mr. Rodolfo in this case. Now, to be free of allegations of illegality under international law, in the process of a taking, a state must satisfy 4 conditions. Now, these 4 conditions are first, that there be no denial of procedural justice. Second, that there is no discrimination involved in the taking from a particular individual on the basis, generally speaking, of whether or not they are a citizen of the state or not. Third, that the taking is for a public purpose. And fourth, that unless it's in the context of a penal code or a criminal violation, that there be an adequate compensation provided to the individual from whom the property was taken. Now, as evidenced by argumentation from my co-agent, Mr. Hatfield, there was a denial of procedural justice in this case, as specified by his analysis of the United States' own laws under the United States Patriot Act and under the federal rules of civil procedure under which this taking was accomplished. Mr. Hatfield demonstrated that the United States did not follow its own laws, and as I will demonstrate, the United States also failed to follow the principles and laws required by the international community. And for this reason, we beg that your Excellencies rebuke the United States government's taking of Mr. Rodolfo's private property. The second, the U.S. further violated the general principles of state sovereignty and non-intervention. One of the most commonly observed and necessary general principles of international law is the prohibition of infringement on the independence and sovereignty, or rather, sovereign equality of states. Now this principle is so fundamental, it is generally considered to be in the realm of jus cogens. Now these sorts of principles are those which are without question. They're things upon which the basis of international relations and international law are created. So this principle is not only a general principle of international law, but it's a general principle of the highest order. And the U.S. violation of this principle of this magnitude of jurisprudence should not go without admonishment by this body.
Counselor.
I'm not clear,
Yes, please.
how is this sovereign equality question implicated by whatever the US may have done here?
Yes, Your Excellency, thank you. The sovereign equality question is implicated by, as Mr. Hatfield explained, the United States' government's actions in engaging a citizen of Narbona, a protected individual of the sovereign of Narbona, in trying to obtain information necessary for litigation within the United States of America. Now, there is a particular methodology that is prescribed by international law under the realm of international custom, which is also supported by the international principle of supporting international comity between nations, whereby this sort of action of engaging an individual directly, and then when they're unable to provide the information required because it's illegal for them to do so, intervening further into the nation by stripping that individual, who's both a citizen as well as a resident of Narbona, of their private property. Now, for the proper means of communication, yes, Your
Counselor,
Excellency.
just to clarify, are you arguing that the U.S. Patriot Act itself is a violation of sovereignty, or just in the manner in which it's been used in this particular case?
I'm arguing that especially in the manner that it was used in this particular case, in which it was basically the information request was targeted, the subpoena was targeted at a private citizen and resident of another country, without going, and then along with that targeting, because that individual was unable to provide the information due to the criminal laws of his own nation, the United States then utilized the Federal Rule of Civil Procedure Rule 37 in the U.S., which allowed for it to create a forfeiture by default. In essence, utilizing other rules within the United States law that are implicated by the Patriot Act in this way, using essentially a loophole to take this property. Now, as Mr. Hatfield you explained, in other cases in which the Patriot Act has been used for the taking of property, it has been done primarily with banking institutions and with the sort of cooperation or work with foreign governments. Now, the proper methodology that the United States government should have utilized in this instance, in that they have no mutual legal assistance treaty with the state of Narbona, is through the process of writing what are deemed letters rogatory. Now, letters rogatory are a methodology by which one jurisdiction requests that another jurisdiction assist him in the first jurisdiction's attempt at the provision of justice. Now, in this instance...
Counselor, I apologize.
Please.
I have to go back just for 1 second,
Sure.
clarify something. So, if a client in one country wants to hold his money in dollars, I understand that there has to be some sort of supervised dollar settlement system, right? And your client wanted to hold his money in dollars, right? So the bank had to have a relationship with a U.S.-based bank to hold the U.S. dollars. I'm wondering, how does that fit within your argument that the U.S. government is breaching sovereignty and in sort of exercising jurisdiction of your client?
Your Excellency, thank you. In this case, it's not necessarily that Mr. Rodolfo required or requested that his funds be held in U.S. dollars. More so that his banking institution had the necessity of being able to trade in U.S. dollars that required them to hold this corresponding banking account with the United States institution that allowed them to participate in the trade of dollars through the federally mandated process by the government. So only because Mr. Rodolfo had a banking relationship with his bank, which was chartered, located in his country, was this implication of the U.S. Patriot Act able to take place, because his bank, being a bank and being a financial institution that is required by necessity, essentially, to have the ability to trade in U.S. dollars, had a corresponding bank account there, That's the only means by which they had the ability to acquire that property. So they essentially acquired property from this bank that had an account, the Bank of Narbonne, that had an account in the United States, which was then, through the transactions that Mr. Hatfield described, credited back, or debited back, rather, to Mr. Rodolfo. So it wasn't necessarily Mr. Rodolfo's desire to hold US dollars that gave rise to this state of affairs. Please.
Counselor, I want to touch on something the professor asked earlier. When it comes to the fact that these are extraordinary circumstances.
Yes.
So there seems to be a classic tug of war here between the protection of liberties and the protection against terrorism. As we've recently been reminded, it is still an ever-present constant danger right now given the current state of the world. So your counselor earlier referenced that there, and you just did recently, that there are other avenues that the U.S. could have pursued to attain the same information. Is it fair to say that those other avenues would have been slower?
You're actually saying thank you. There is a possibility that those other avenues would have been slower. In previous times, letter surrogatory were a very slow process, though through various treaties that have been entered into by governments throughout the world, including the Hague Convention on Evidence of 1970, that process has generally been hastened.
So given that it is admittedly slower, how then do we strike the balance between trying to protect against terrorism where time is of the absolute essence and what you're advocating for, that we read these rules very strictly such that we force the U.S. to use these other avenues? How do we strike that balance?
Your Excellency, thank you. This is an important balance to strike, and this implicates not only the balance that in times of violent acts such as terrorism, but in all times of international relations. And it's important to remember that these general principles and customary laws of international interactions are designed in order to protect the security and safety of the international order. It's violations of these sorts of sovereign rights. It's actions that are perceived as hegemonic by some individual states that some publicists believe actually lead to and essentially embolden individuals to take violent acts as their only recourse. It's these unfortunate sorts of postures of hegemony that many violent actors are responding to with the only means necessary through violence, through bombings, through these sorts of terrorist activities that we wish to also forestall and stop here. And we believe that one of the ways to do that is to ensure that the larger powers of the world, such as the United States, are also required to play by the same rules as all of the other states in terms of their relations with other countries and with the citizens that are essentially protectorates of those sovereigns. So by engaging in the appropriate process of utilizing letters rotatory, the United States government would not only engage in this process, which is not only appropriate, but is also mindful and respectful of the sovereign rights of Narbonne. Now, by not doing so, the United States essentially violated the international general principle of international comity. Now, this principle of comity, at its heart, says that courts should not act in a way that demeans the jurisdiction, laws, or judicial decisions of another jurisdiction. Now, in the instance where two nations share common public policy ideas, one of the nations should submit to the laws and judicial decrees of the other. But comity is only effective to the extent that foreign laws or judgments do not directly conflict with a foreign country's public policy. This, for example, is in cases where the United States will not enforce foreign defamation judgments, where the foreign jurisdiction did not provide for the same level of free speech as the U.S. Constitution would. Or many countries will not extradite individuals to the United States of America if they might face the death penalty, if the United States does not grant immunity on the possibility of this sort of punishment. So the United States has been, as Mr. Hatfield suggested, very accustomed to utilization of these multilateral, or rather mutual legal assistance treaties, and is very accustomed to gaining this evidence through just the requirements of the treaties they've entered with other countries. And when they don't have a treaty, as they don't with Narbona, it is necessary for them to enter into this process of engaging in letters rogatory. This shows a respect for the jurisdiction of Narbona, it shows a respect for the sovereignty of Narbona, and it also shows a respect for essentially the sovereign state's necessity, ability, and requirement to provide for the protection of its own citizens. Lastly, I want to touch on the fact that the United States recommends that Mr. Rodolfo violated good faith in his refusal to provide information that was requested by them in their interrogatories to them in the subpoena they provided to them. In all reality, what has happened here is that the United States violated the general principle of good faith in international public law through its actions. Now, the history of this principle traces back to times immemorial, going back to the individuals including Grotius and Suarez who wrote about good faith. Now, they conceived of good faith as a constraint upon nations that would act in a manner that takes into account the reasonable expectations and needs of other nations in the international community. Now, this concept is cited as an essential ingredient in many of the primary treaties that govern international relations, including the United Nations Charter, Article 2, Section 2, which states, all members, in order to ensure to all of them the rights and benefits resulting from membership, shall fulfill good faith the obligations assumed by them in accordance with the present charter. The Vienna Convention, Articles 26 and 31, which pertains to the interpretation and action regarding treaties, also implicates good faith as a necessary requirement. And moreover, in the nuclear test case, the ICJ itself proclaimed that one of the basic principles governing the creation and performance of legal obligations, whatever their source, is the principle of good faith. Now, good faith oftentimes is thought of only in the context of treaties, and as we've said time and again, there is no mutual legal assistance treaty here to guide our analysis. Yet as historic individuals that are commentators and publicists of international law, going back to Grotius, as the International Court of Justice itself has stated, and as the Friendly Relations Resolution of the United Nations General Assembly passed in 1970 proclaimed, every state has a duty to fulfill in good faith its obligations under the, quote, generally recognized principles and rules of international law. Now, the U.S. violated the general principle of good faith by first failing to engage the state of Narbona in the customary process in the exchange of letters rogatory in order to acquire the information that it required for litigation in the United States jurisdiction. Secondarily, it violated the general principle of the doctrine of acquired and vested rights by stripping Mr. Rodolfo of his property without the protections of procedural justice. Now, this goes back to the implication of good faith as being something that takes into account the reasonable expectations and needs of other nations. As such, when a nation such as the United States goes into a foreign land, deprives one of its citizens and residents of its property without even utilizing the procedural processes that are required by its own justice system, we have to say that that is an act that was not done in good faith. And lastly, by violating the general principles of state sovereignty, non-intervention, and international comity, by negatively impacting the citizen and resident of Narbona, and by not directly engaging the state of Narbona, again, to acquire the information that it sought, the United States violated its duty of good faith here. Now, due to these violations of international law by the United States of America, we beg that this tribunal consider the following. We beg that the tribunal takes whatever action available to it to restore Mr. Rodolfo's property rights. Secondarily, we beg that this tribunal condemns the United States' demonstrated foreign policy of disrespecting foreign states with whom it does not have a mutual legal assistance treaty by foregoing the customary process of utilizing letters rogatory and instead requiring those states' citizens to violate the laws of the sovereign or to seek its special permission to divulge otherwise protected information in violation of the general principle of comity. Now, the ANLI, a group of respected publicists in the United States of America, in their forward, in their comments to the restatement on the laws of international relations in the United States, stated itself that the United States has been moving this conversation in a direction that is not adhered to, that is not welcomed by the international community. The international community has created laws that are blocking laws, that are banking secrecy laws, laws that forbid their citizens from providing information in the United States jurisdictional proceedings for this reason. And for these reasons, we beg Your Excellencies fine for Mr. Rinaldo and for the student